Impeachment is not how you register disagreement with decisions.
That's what you're for, right? That's what you're there for.
That's what we're there for, yeah. Only real political science innovation in our Constitution. I mean, parliaments have been around for 800 years, and obviously executives, is the establishment of an independent judiciary. That innovation doesn't work if it's not, the judiciary is not independent. Its job is to obviously decide cases, but in the course of that, check the excesses of Congress or of the executive, and that does require a degree of independence.
Let's talk about something a little more important, a little more substantive. I think most judges would agree that judicial independence is crucial. Do you agree? What do you think?
Oh, yeah. I mean, it's central. The only real political science innovation in our Constitution, I mean, parliaments have been around for 800 years, and obviously executives, is the establishment of an independent judiciary. Even places you think are similar to ours, like England. The judiciary in England was part of Parliament. I mean, they sat in the House of Lords, and because Parliament was supreme. But in our Constitution, judges and the judiciary is a co-equal branch of government, separate from the others, with the authority to interpret the Constitution as law and strike down, obviously, acts of Congress or acts of the president. And that innovation doesn't work if it's not, the judiciary is not independent. Its job is to obviously decide cases, but in the course of that, check the excesses of Congress or of the executive, and that does require a degree of independence.
What do you think of these calls for impeachment of judges based on the decisions that they've made?
Well, I've already spoken to that, and impeachment is not how you register disagreement with decisions.
That's what you're for, right? That's what you're there for.
That's what we're there for. Yeah.
So lots of decisions that you make interpreting the Constitution have real life practical consequences. So just as for example, the Second Amendment decisions result in more people having guns. And the Obamacare decision resulted in more people having health insurance. Obergefell resulted in more same-sex marriages. Do you think about those practical consequences when you're interpreting the Constitution? And should justices think about those practical consequences when they're interpreting the words of the Constitution?
Mainly no. To both of those questions, because if you do that, with one exception I'll talk about later, but if you do that, you're kind of putting yourself in the place of the legislator. You can say, for example, a consequence of the Second Amendment decisions are, well, more people have guns, and so there's more accidental shootings, more shootings. Or you can say the consequence is that more people are armed, and therefore they're in a better position if there's foreign invasion, as there was with the British shortly after the adoption of the Second Amendment, so that's a good thing. Now, if you decide one of those or the other based on your view of what you think is best, you would be substituting your own view for that of the people who wrote the Constitution. So, no, I don't think that's not a big part of at least how I do my job, sort of what a purposivist approach is what people would call that, because I think you're making yourself the arbiter of what people were trying to accomplish in that law, when you really need to be doing is sitting down and reading it, in its appropriate context and trying to figure out what they meant.
Yeah.
Now, at one extreme, if an interpretation you adopt leads to some absurd result that nobody could plausibly have intended, then the consequences make a difference. But I think it's more important to figure out what the people who wrote the law had in mind and what they meant by the words they used, rather than think, what is this type of legislation for?
Yeah.
Because then the interpretation goes flip-flops.
Yeah. So you really are a terrific writer, and you were back in law school as well. I still remember you're telling me that if I had a sentence that had 3 prepositional phrases or more, go back and rewrite the sentence because the sentence needed rewriting. Where'd you learn to write? And is there any one person who you credit for teaching you how to write?
Well, I think the way to learn to write is to read good writing. And I read a lot. I liked Conrad. I liked and Elmore Leonard. I mean, Joseph Conrad, if you want to write long and flowing, elegant sentences, and Elmore Leonard, if you like punchy sentences. And I think that helped a lot. Mm-hmm. When it came to writing briefs, though, I had a secret weapon. I have 3 sisters. None of them is a lawyer, and yet they're very bright. And I would send, for most cases, a copy of the draft brief to them and ask them to read it once, and then I'd call them and ask them what it was about and who should win. And if your writing isn't clear enough for somebody who is an intelligent layperson to get through it and to understand, basically what's going on. I mean, they wouldn't say, under ERISA this or that, but they say, the guy who, was driving the truck, should have looked left and he looked right, and, the safety brake didn't work, so the other person could pay. And if it was the right answer, then, because I see it today, and I bet you do too, when you read so many briefs and read them carefully, but it's not like you can devote as much attention to however many cases you're hearing. So you want to make sure that somebody who's going to read through it once, maybe a little more quickly than you'd like, really gets the gist of what you want. The other thing I'd like to do is read aloud. And again, no matter how complicated it was, you should be able to stand up and read it to somebody and have them basically follow. I mean, otherwise your sentences are too convoluted, not direct enough. And I think those are 2 things that serve me well.
Do you still try to do that now when you write decisions? You try to make them simple and
people
accessible?
are always complaining and walking down the halls, and they're reading out loud, and no, they don't do that.
But you try to make your decisions accessible.
And I'll tell you, I mean, it's not. There are cases where we don't necessarily study every brief, and if you file a brief and you can't, I can't read through it once.
Right.
It's going to, okay, I've got to read through it twice. And, sit down with the law clerk and say, what do you think this is about?
Yeah.
And I think people place too much emphasis on, showing off their intellectual sophistication or the nuances instead of just being very direct in your writing. And I always think, particularly in the cert petitions when I was doing those, it's very hard. I don't know what the rate is now, 2% or less than that get granted. I always thought it was important to put something in that would catch somebody's eye. Even I had a case once involving, it was mining in Alaska, and it involved something called the Red Dog Mine. It was out in the middle of Alaska. And so I figured maybe it would help. So I put in the first page and a half is about why it was called the Red Dog Mine. And it was because you get these stories in Alaska where somebody has to fly out to get emergency insulin, and they fly back. And this was flying back, and the guy who had his plane, he always had this red dog, in his plane. And the plane coming back crashes, but the dog, survives. The pilot doesn't. The dog runs to the village, and they get the insulin and all that. And then hopefully you read on, and it's about some mining regulations or something. And but hear me out. When I got on the court, the first thing Justice O'Connor said to me when we were sitting down for lunch, and I said, "I love that story about the dog." Yeah. But I mean, they denied cert, but that that happens.
But they read it. But
you knew. I bet she finished reading it too.
Yeah. So when I write decisions, I tell my law clerks that half the people who read the decision are going to think I'm an idiot because they lost, but I want them to at least understand why I'm an idiot, at least why I made the decision that I made in the case. Because I think it's important to write so that it's accessible for people, and judges do the same thing, I think.
Yeah, I think so.